Good afternoon. Our next panel will be in-house counsel discussion of trade secret law. We are bringing on our third panelist, Anthony Curtis, who will be joining us online. In addition, we have moderating our session, we have Devin Grant, and in person, we also have Ulysses Williams III and Michael Forzano from Pall Corporation. That will be our 3 o'clock session, in-house counsel discussion of trade secret law.
Hello, everyone in attendance and online. We're going to go ahead and start, and hopefully we'll resolve the technical difficulties shortly. So briefly, we'll, I guess, have brief introductions for each of the participants on the panel. This, again, is the discussion regarding trade secret law in-house. So if you could briefly introduce yourself.
I'll start. Michael Forzano. I'm the Chief IP Counsel at Pall. I've also been serving as Interim General Counsel since April of 2021.
Ulysses Williams, IP Counsel at Pall. And Howard Law graduate, class 2016. See a number of my professors out here. I remember each and every grade you guys gave me, including someone who gave me a C. I'm not going to name any names. Or did I earn that?
First question, perhaps you could give us a little insight. So I know you have interactions with products and technologies teams and have a variety of means to protect intellectual property that they generate. Can you speak to, I guess, the use and importance of trade secret in your practice?
Sure, I'll start with that. So what we've done at Pall, and I know that our sister companies throughout the Danaher organization, who's the parent, we follow a number of practices which we consider best practices for identifying and protecting our intellectual property, especially trade secrets. One of the things we do is we ensure that the IP professionals of the organization are somewhat embedded in the R&D organization. We don't work for the R&D organization. We're not, getting paid out of that organization, but we're totally embedded. We're invited to all of their key strategy meetings. We have programs set up so that product development has a responsibility to work with the intellectual property team to make sure that we've identified any possible inventions coming out of the new product, whether those inventions be patentable subject matter or they be trade secrets. We also have a regular cadence of invention disclosure opportunity meetings, sort of like a Shark Tank. And the idea is everybody wants their 15 minutes of fame, and we give every associate an opportunity to submit their invention disclosure. We give them a little bit of a financial reward just for doing that. And then they attend one of these monthly meetings, and they're presenting as if to the Shark Tank what they think they've come up with. There's a problem. Here's how the problem has been solved. Here's what we think is a better solution to that problem. And therefore, we think it's innovative. And the innovation board that's listening in on this are, for the most part, the leaders of R&D and then the IP professionals. And so even for a very young associate in our organization, there's a sense of, being given a stage, being given that inclusiveness that even me, my first year, in the lab, if I think I've invented something, I'm going to have 15 minutes to speak about it. And leadership of R&D is going to be listening, as well as the IP professionals. So that's have anything to add to that, sir?
Tony, I saw your name flash up. Are you online? Can you hear us?
I can hear you, but it's very, very quiet. I can barely hear anything that's being said.
Gotcha. So we were just going through the initial questions. If you can briefly introduce yourself.
Sure. I'm sorry that I can't apparently activate my camera. It's I'm being blocked from doing it otherwise. But then again, I don't pity you because you probably don't want to see what I look like anyway. So my background is I've got a doctorate in electrical engineering and physics and AA degrees. I've worked both as in-house and outside counsel. Currently, I'm working for Schwegman, Lundberg, and Woessner, which is a fantastic law firm. I have multiple different types of experiences with various industries as in-house counsel, and primarily on the patenting side, but with a significant amount of forays into trade secret as well.
Thank you. So our first question was basically related to, when you're getting or receiving innovation or having those discussions with your clients and trying to figure out means to protect that intellectual property, what goes into your thought process, or how does the trade secret form of protection fit into your policy or your thinking?
I think in general that depends on where the management wants to go with their ideas of what resources they want to expend in various categories. Of course, patents have a significant amount of resources associated with obtaining a patent in one or potentially a fair number of countries, whereas trade secrets can be a lot easier to protect in certain realms. And of course, the trade-off between patents and trade secrets, or one of the trade-offs is that it's not only the protection, the length of time of protection, but also it's the things that you can protect, especially in the last decade or so, where we've seen the Supreme Court stick their noses into the patent field, and as many people would suggest, not in a particularly encouraging way for patentees. Trade secrets have become much more of much more value, and so the calculus on whether or not to file a patent application versus whether or not to keep something a trade secret has also changed. But primarily, in areas in which a company is really driving towards, which is defined by the CEO and CTO generally. I feel like the idea is to obtain whatever protection you can within the bounds of or the constraints of the assets that we have available to put forward for that.
Yeah, I agree with that. And I'd add also, in terms of what we're thinking about trade secret protection versus patent protection, is the ability for an external outside party to independently either discover this technique or improvement by themselves independently, or I guess the ability for someone to look under the hood, so to speak, of some technology or a piece of technology that we have, and their ability to reverse engineer what we have based on looking under the hood. I think that's a big factor in determining trade secret versus patent protection.
I'm going to add to that. There's one other thing that we look at. Across most of the opcos at Danaher, you could say that it's not a consumer-oriented company. We're business to business. So that's certainly going to have an impact on the way that you look at the intellectual property that your companies are developing. And then we look at it a little bit deeper, and we go another level down, and we say, who is the customer for this particular product? So for some of our organizations, the customer is what we call a defender optimizer, okay? So a defender optimizer is someone who wants a solution to a problem to fit into their process. And once they have it, they don't want to touch it. For 20 years, 30 years, they don't want to touch it because that's going to create problems for them. So in that kind of a situation, what we determined, I'm looking over there at Austin Wang, one of our colleagues, we determined that in those instances, trade secrets might be your more important forms of intellectual property rather than patents. Because obviously when you're filing a patent, you're filing it for the world to see. Anybody with ordinary skill in the art can practice the invention without undue experimentation or development. With a trade secret, you're not telling anybody anything, okay? So you've got this product that solves a problem, and the way that you make it, the manufacture of it, you've determined should be a trade secret. You might have that thing on the market for 30 years, but all of the manufacturing techniques are trade secrets, and that defender optimizer is quite happy to keep buying that same product for you because it's solving the problem, and it doesn't matter that it's out there 30 years. Your patent would have expired a long time ago. So that's another calculus that we put into, do we do a trade secret or do we do a patent?
And probably just to add a further bit, I think probably in general, the more specific the market, as well as depending on the amount of money or the lucrative ability for the market itself, also is a factor in calculating whether or not you want to file a patent application or trade secret. In a sense, where you have to optimize for various clients, it might make sense to maintain a trade secret because you have to do so many optimizations. Or if you have only one or two clients who have very, very special niches, then you're right. I agree with you entirely. Patents tend to make less sense than trade secrets.
So a question from the audience. When you think about trade secrets, how do you deal with it when you have to, or maybe you don't, outsource manufacture, number one? And then how do you deal with it when you're entering into a joint venture?
So that's a great question. We personally at Pall historically have not outsourced a lot of product, and those products that we have outsourced, the technology is quite obvious to anybody, so they can make it as well. But it's the material that's inside of the device, and the material we make only in our factories. Okay, so just so you understand, Pall Corporation, we're a filtration separations company, and we sell to all industries that need very purified fluids, basically. So the engine of this device is a membrane, a polymeric microporous membrane. We never give that to a third party to manufacture. Now, the device itself, which is, pleating the membrane, sealing it in some kind of a housing, that sometimes we will send to a third party, but they're receiving our membrane, okay, and then they're assembling.
Yeah, so
I'm sorry, go ahead, Tony.
oh, I was just gonna say, that is an excellent question, because there are a lot of variables. I think there are a certain things that you can do ahead of time to prepare yourself. Continually performing trade secret audits, for example, so that you have an identification of particular trade secrets, as well as recording and reviewing this list periodically. In general, also limiting access to only those employees or third parties that need access to this. Far and above, I think, NDAs and other agreements where you have to you make it clear that not only the parties that you're providing to have this requirement to keep the secret and know-how confidential, as well as anyone that they absolutely have to share it with down the line, is an important part, because every litigation case that you're going to have, you're going to have to identify the trade secret. You're going to have to show that you tried to keep it secret, that you had an agreement to keep it secret, and even then, it's sometimes quite problematic. One court case that I remember against a Chinese company, the American company won, and the juror foreman said, "You won, lots of luck collecting," that sort of thing. So overseas can be quite problematic. In the US, less so, but there are certain commonalities among the things that you should do to at least either minimize your exposure or maximize the potential for actually collecting if you have to litigate. So I don't know if you have anything to add about for this.
Yeah, I would. I'd add the other bit being the indefinite obligation of maintaining the confidentiality of the trade secret, which having a lot of NDAs and agreements have limited time factors for confidentiality, say 5 years, 10 years. And it's the diligent attorney or IP professional who specifies that, okay, that's fine for general confidential information, but when we're talking about any and all possible trade secrets, we're talking about an indefinite obligation of confidentiality. And there are a few court cases in which the trade secrets were defeated by the fact that there was no indefinite obligation of confidentiality written in the agreement.
It's interesting. There's a case just last year on that specific point where the duty of confidentiality lasted for 2 years, and the person took that, and 2 years and 1 day later, they went ahead and used it, and the company that was suing lost the case. So indefiniteness is very important. Yes. Sorry.
So, along those lines, how have those recent court cases or trends helped shape your trademark policy? I mean, trade secret policy internally?
I think there's just been consistency, at least in our organization, that we've always been extremely cautious with our trade secrets. So I think Tony was just mentioning a need to know. That's a culture. You have to develop that culture in your organization, which means everybody understands that a trade secret is a very special animal. Everybody has to understand that even though I'd like to know about it, that's not good enough. You have to actually have a need to know about it. And if you don't have a need to know about it, don't be insulted that we're not giving you access to it. The managers have to understand who in my organization is going to touch important trade secrets. Do I need to get some training for them from the IP professionals? And so we do that. We periodically go throughout our entire organization globally and identify groups of associates who are going to be touching trade secrets, and we provide training to them. And obviously, nothing's ever static, so you don't have the same employees working for you for 33 years, except for me. But we have people constantly coming in and out the door, and the idea is, as part of their onboarding, they get a little bit of IP awareness training. But if they're now in an engineering group that's working on a manufacturing line, which is where the trade secrets oftentimes are located, they're going to get a more enhanced IP training so that they understand how important the trade secrets are, how difficult it is for us, to protect them, and therefore they have to be extra cautious themselves in their utilization, their touching, and who they speak to or share the trade secret with. So it's all part of the organization.
So to follow up on that line of thinking, what do you do when the employees depart from your organization?
We have an exit interview,
Mhm.
and in the exit interview, we have the associates sign a document saying that they understand that they're under obligations of confidentiality that have no term limit to them. And to the extent that they had any company information or any company property, which includes intellectual property, that they have returned all of it to the company.
So how do you,
No, it's
I don't
fine. It's your
wanna
question.
ho-
'Cause
I
I get
don't
it. I
wanna
agree. And
hog-
that it's
I don't wanna
difficult.
hog
There's
the
no
spotlight.
hard line really between what an employee knows or what they've
Yeah.
learned or what they've sort of self-developed in the course of their employment versus what constitutes a trade secret of that company. So your question is pointed, and I get it. And there is no hard line despite the confidentiality agreements. It's still difficult to draw that line in the sand, so to speak, between what they know, versus what's company IP.
so how
Yes,
do you
ma'am.
think about the FTC's new legislation or proposal about non-competes?
I definitely have been looking at this recently. It is devastating. It brings into play a whole bunch of factors that I don't think the people at the FTC have realized, and leaves big holes. For example, for those of you who don't know, the FTC rule, for example, allows for the transfer of goodwill, which is in some sense a trade secret, but only for a substantial owner, which is 25% of the company. So if you have multiple people who own the company, if it's a small company, you have no right to transfer any of these trade secrets if you sell. It applies to all sorts of, it's so broad, it applies to non-disclosure agreements as well as non-compete agreements in certain cases. And even worse of all, it's retroactive. So it would require, at this point, it requires employers to give individual written notices that the contract clauses that the employee has already signed have been rescinded, and you have to reiterate that or re-have them sign things, as well as independent contractors, as well as all past workers. You have to send it to their last address. This is, as far as I can see, it's a pie in the sky thought, but it's very unworkable from a business perspective.
We welcome the participation. You cannot by all means. I said we welcome the participation. By all means, you have more questions, fire away. This is what we're here for.
We can move on to the next question. So along those lines of the most recent and pressing problems, are there any additional problems that have come up that you encountered with the trade secret protection, and have you implemented any tactics to address some of these issues?
Well, I'd say for starters, extraterritorial enforcement. And I think someone has mentioned that, as this becomes more of a global economy and a lot of emerging economies and countries in which maybe you start shipping or manufacturing or start having manufacturing done in these sort of countries that are, like I said, emerging economies, enforcing a trade secret. I don't know how that's done at the moment. Especially in places where it's already notoriously difficult to enforce IP generally, even patents. So I think this is something that companies are going to have to get a grip on, and all ideas are welcome, for the future here.
Yeah, in addition to the issues that are just certain well-known, there are certain well-known actors that are not afraid to obtain valuable information in nefarious ways. There's also other economies. The U.S. has had a relatively long-term stable set of employees. People don't tend to move around as much as other places in the world, versus other countries. Notoriously, India is what I'm thinking of, but that's not to say they're the only ones. But employees can move around as often as every few months, and it's very, very hard to, I think, maintain trade secret in that type of environment. One of the keys that I didn't hear mentioned was, of course, determining the proper level of security for a particular trade secret. The more important the trade secret, the more security it should undergo, as well as making sure that none of your employees is accessing or retains files that they otherwise shouldn't have, which can be very, very difficult.
So we do that in the organization. There are certain trade secrets that literally, it's like the Coca-Cola formula. Two people have access to it. Not quite, but it's something like that. And a lot of our trade secret now is in a digital form, right? So these are bits of information that are now in a database. And one of the things that you have to do as in-house IP professional is you have to partner with your IT department. You have to partner with the teams that are building these databases, because if you leave it, up to the IT people and the engineering team that says we need this database that has all this information in it, they'll just go, path of least resistance. And I don't mean this in a negative way against the IT people, but okay, we'll just put everything in this giant, database, and these 600 associates globally get access to it. Well, that's not the way to go. You've got to say, okay, what is this particular individual's function, and what are the types of projects they will work on? How do we set up an architecture in this database so that we can do that? And that's exactly what we've done at our company. And I've been involved in it. And I have to tell you, at first I hated it because I'm not an IT kind of person. So I had to learn a lot of jargon and learn a lot of, technology that I didn't quite understand initially. But now that I've gone through it, it's very empowering. It's really, and you feel like you're doing the right thing. You're helping the company in protecting its IP. Well, that's your number one job, right, as the IP attorney. But you're also helping the engineering team be more efficient, and you're giving access to the data that the engineers need, and they need it from different locations in the world, but you're doing it in a meaningful way. You're protecting the organization. So that is absolutely imperative. If you haven't done this as in-house counsel, you have to start becoming buddy-buddy with not just the R&D people, but also with the IT people.
Sure, let's see. From my former professors, I'm sweating.
So with respect to that issue, do you find that you get the kind of pushback from the engineers as well as the IT people to say that you're impeding the productivity, right? But they say, well, we know your job is to protect the IP, you're the legal job, but we have to produce. And so we need to collaborate, and you're building walls when we need those walls to be lower. Do you find you get that type of pushback?
There was definitely a little bit of pushback, Latif, but what I would say is this, because we laid the groundwork over the years on educating all of these stakeholders on what IP is, how it works, how to protect it, where companies lose their rights to their IP, they get it. And so the pushback is minimal. The pushback is more of, oh, that's going to be hard. Well, guess what? Protecting IP is hard. We've got to do it. And that's the kind of pushback we got. Really, it was just, it's a lot of work. Not, you're making it difficult for us to be productive. We're not, actually. We're doing it in a meaningful way. We've got different types of engineering groups that have different responsibilities, and that database may have all kinds of data in it that I only need this much access to. So let's be meaningful about how we set that architecture up. It's definitely a long process. I would say the project that I worked on, it was about 1.5 years for us to really create this architecture, because it's so complicated the way our business is. We don't have one factory that makes the product from start to finish. We have this factory that makes a component, and then it ships that component to another factory. And then, it might go to yet another factory after that. And each one of those factories have engineering departments, right? So.
And I'd add that the training and culture, at least where we are, is been done so well that I have the engineers who, I'm the IP attorney, talking to them or asking them about inventions and technology, and they're saying they can't tell me about that because that's a trade secret.
Yeah, I mean, training is key. And I think that the engineers and employees who have been engineers and employees for several years understand the hoops that you have to go through. I think one of the cores, of course, of this is also making sure they understand that this is not only just part of their employment responsibilities, but it's also building the company up. And it's giving them some sort of pride in taking part in making sure that the intellectual property is of what they're doing is protected. So pride is a good thing.
One additional question is, so going forward, given that multinational aspects are developing and for companies and addressing things worldwide, what are some of your future considerations on trade secret protection, and what are those problems that you can foresee on the horizon?
I'd say the difficulty in what we might assign or think is a trade secret, and there's a lot of case law that's been coming out that if there's something that, and I took some notes here, particularly that the Bimbo Bakeries case, in which they were ruled, the court ruled against them and them seeking to protect their trade secret because it was a combination of 2 known ingredients and 2 known techniques that, even though they held it as a trade secret, it was sort of objectively viewed as the court as not rising to the level of trade secret because these were known combinations or known components. So I think, given the vast diversity of what falls under or what could be a trade secret, I think there's going to be a lot of difficulty enforcing some of the more known or rudimentary inventions and such in the future.
There are a number of different court decisions that have started to come out as a result of DTSA cases coming online. Number of cases has been uh, steadily increasing since it's been enacted. But in general, I think that's correct. The trade secret, the idea, the definition of a trade secret has not particularly changed since the Espionage Act of, I think, 1996, where it's not only that it's something that's not commonly known, but it's something that can't also be easily figured out or readily ascertained. And the Bimbo case, you're right, relied upon the fact that this is a bunch of common ingredients. They even told you the ranges. That kind of quote unquote secret is quite difficult to protect when everybody knows everything. It's just a particular combination of things that you can easily do. There are a lot more cases where the decisions are much tougher questions about, is this able to have been readily ascertained? In particular, one of the big cases from last year, I think Massimo versus True Wearables, was there was an algorithm that was applied for detection purposes, but it was published in an IEEE publication in a different field. And so the question came down to, is this generally known? Well, it's a question of fact, because it's a question of, would someone in the patent parlance, one of skill in the art, look to this other field, or would someone actually look at these types of articles? If not, it's probably a trade secret. If so, it's less likely to be a trade secret. That's the idea of generally known and readily ascertainable. There's another case from last year, Lifespine, where it's an actual surgical implant. And the question is it readily ascertainable? Well, the company took a lot of precautions, i.e. everyone who touched it only had a need to know and had to sign NDAs. So the only way of getting access to it was through the patient themselves. So, I think, just as a continuing on with your idea of what is generally known, what is ascertainable.
For those programs or startup companies or companies that have a less robust patent trade secret policy than you've instituted, what would be your recommendations for getting themselves up and running in a adequate manner as soon as possible?
Hire a great law firm.
I was just going to say, you could certainly start having a conversation with outside counsel, who should be able to provide you with some guidance on how to develop a program, to protect your trade secrets. There's actually, information available online. You can search, for trade secret protection and find all kinds of papers, written by both law firms, written by legal scholars, and also written by in-house counsel at different organizations who are willing to share their best practices with you. And I'm sure some of you in the audience, you've worked with PLI, or you use PLI as a resource for information. You can get information like that from PLI as well. So you certainly can sniff around the universe and get some general ideas to start a program.
Yeah, and I was going to add, this could be something, I know Latif was talking about instituting, and I think, the marching orders were to institute these sort of community hubs. I think that's something that could be a thing, something that could be instituted at one of these community hubs, because clearly startups by definition are going to be pressed for cash and for resources. So I think, them going to see outside counsel, I don't think they can afford to talk to you, Scott, at least not yet.
At this time, given that we have about 5 minutes left, we would ask if there are any other additional questions.
Yeah, thank you for being here. It's been really interesting. I do have a question. You mentioned earlier that the value of trade secrets has kind of been going up, they're becoming more valuable to a company. Do you expect this trend to continue? And do you see it as a good thing? And I ask this because there are arguments that trade secrets can stifle innovation in some perspective, especially, when compared to patents for things that are patentable. So I'd be curious to have your thoughts about that.
I think,
Oh, good. Please.
just as a concept, to begin with, I think you're right. The amount of trade secret judgments, the valuation of trade secrets has increased as the economy has increased. The last couple of years, we've seen $2 billion judgments in several cases, to up to the high hundreds of millions of dollars of cases. But I think you have to realize something when you're talking about stifling invention. That argument is made a lot for patents, but for trade secrets, you inherently have to misappropriate the trade secret. You have to be doing something wrong to be liable for this. If you independently, as a company, as a different company, figure out the same thing, the same formula, the same algorithm that another company is doing, there's no issue here. It's only when there is malfeasance that trade secret damages attached to something, and so it makes less of an issue in a trade secret stance. But I'm sorry, I think I interrupted you.
Were there any additional questions? Oh, third.
Oh, no.
And I know they can't hear me on the Zoom. I would also just add a comment that what we oftentimes don't think about is the way in which trade secret can actually encourage and foster innovation, right? Because in patent, right, I come up with stage whatever. Well, that's it. If you want to build upon that, you have to move in a direction that's non-obvious, right? And so we're not going to have further innovation along those lines until someone perceives the opportunity for the next big leap, right? And so there's not much incentive for you to try to figure out how to tinker around the edges. In fact, the only people that's going to do that is if you're trying to avoid infringement and doctrine of the equivalence, right? But with trade secret, not only, as was pointed out, that independent discovery is fine, but tweaking little leaps, that's also fine. So even if you independently discover or you get the information improperly, right? If you see an opportunity to just edge it up just a little bit, and oftentimes what many scholars and practitioners point out is that that's typically how we get to that next great leap, right? It's the trade secret tweaks that are the little steps until we get to the next big leap. Is that what you guys have found?
That's exactly what I've experienced at my company for 30 plus years. So we make a product, we get a patent on the product, on the composition of matter, on the product, on the use of that product in a particular process. Okay, great. So those patents run out in 20 years. Meantime, we've developed a way to manufacture it. Well, we don't sit on our laurels on, well, we started this manufacturing approach 20 years ago, and we're still going to, make that product exactly in the same manufacturing environment. Why? Because there's competition anyway. Our competitors are making similar products. They're outside the scope of our claims, but they've learned enough from our patents, and they know generally how to make a solution similar to ours. So our patent's less valued, but we've been making the product longer. We see that we can actually make the product faster. So the efficiency goes up, okay? And it becomes cheaper for us to make that same product. We've learned how to make that product with less defects. So again, it's more efficient in the sense that you have less scrap. maybe visually, certain customers look at the product, and from a visual perspective, if it's got some kind of mar on it, oh no, we're not gonna, that we're not accepting it. Meanwhile, that has nothing to do with whether or not that product's going to perform the way we've certified it will perform, but they're not going to accept it. So we've learned how to take those things out as part of the manufacturing. So those are all examples, Latif, of where we have incrementally improved our own manufacturing process, and every one of those steps we've taken could be a trade secret, right? So,
And I'd
Not to
add there
mention that-
also that in terms of increasing and promoting innovation, is that everything in terms of patentable subject matter that could possibly be a trait that we could derive value from as a trade secret won't qualify necessarily as a patent, but you still could be entitled to protection as a trade secret. And I think that's the biggest thing, and applies more widely to more than to folks who might have less or might not have the ability to even seek a patent. So I'd agree with you.
Right. Certain manufacturing tweaks, client lists, et cetera, wouldn't qualify or would be very difficult to get a patent on, but might be very, very useful in terms of putting yourself ahead of the competition, and as well as your name. This is with the intersection of trademark comes into the play, because you can do this stuff better. People trust the quality of what you're doing, or they like, design patents. They like what the way you've produced this case, or this widget, or whatever it is. But they trust your name. So trade secrets is complementary to patents in a very, very important way. And as you said, it's not only the small things, but it's making things better internally to satisfy your customers and improve your image.
And actually, Ulysses, I finally got, the student has surpassed the professor, because I finally caught up with the breadth of what you were saying, because the social justice implication of that, I mean, it goes back centuries in the US, right? Whether it is stuff that's in the public domain or stuff that is the subject of a patent, oftentimes marginalized innovators don't have the resources to make the big leap. But with the limited resources and necessity being the mother of invention, they can take things that are already out there, included patented things, figure out ways to do little tweaks, right? Little ways to take it in a slightly different direction. And you can stay within the patent framework, right? You can license the technology, right? Add your little tweak. And now what you have is all boats rising, right? Because here's this other company licensing your technology, okay? Going out into another niche market that you aren't in, right? So they aren't even really competing with you. But the little variation that they're doing is not to the level that they can get that brings into play, blocking patents or anything like that. But they're using this launch pad to do something and create out a little niche market for themselves while still paying back a license to you. So yeah, I see. Now you've taught me something. Thank you.
Well, it looks like we're a little after 4 o'clock. Tony, Michael, Ulysses, thank you so much for the conversation and the insight. Greatly appreciated, and I hope everyone enjoyed it. And once again, thank you.
thank you. Thanks, Devin.
Thank you for having me.
Thank you, everyone.